to winning isn't easy. I'm going to give you a lesson on what not to do when your doctor says, I don't support your claim anymore, or they won't comment on your ability to work, with suggestions about what it is you need to do. Now, when the disability insurance carrier accepts your claim, they put it on diary, and they will want you to have your physician complete on a regular basis attending physician statement forms. These forms are going to ask your doctor to comment on your restrictions, limitations, and your ability to work. If your doctor says, I don't want any part of this disability process, I'm tired of filling out forms, or I don't think you're disabled, you're in trouble and you're going to be set up for a claims denial. I want to tell you the story of Mr. Messing, who lived up to his name and messed up his disability claim big time when his doctors would no longer comment on his ability to work. Now, the lack of medical support will doom your ERISA disability claim. And in Messing's case, he claimed in 1998 he was disabled because of depression. He said he was unable to handle the stress of being a trial lawyer. Unum accepted that claim and they paid benefits until 2018. And at that point, they said, I think you're able to work as a lawyer, and they terminated his benefits. Now, his treating physician had opined in 2017 that he was unable to work. But by 2018, the same psychiatrist refused to express an opinion as to his ability to work. Now, you, just like Messing, have the burden to prove that you meet the definition of disability. Now, despite the fact that Messing was a trial lawyer, he screwed it up. He didn't find a new provider to treat with, and he didn't have any medical provider to confirm his inability to work as a lawyer. So what did Unum do? They pulled out one of their key tools from their disability denial toolbox. They requested an insurance medical evaluation. Now, disability carriers will call it an independent medical evaluation. That's bull. There's nothing independent about an insurance medical evaluation. As expected, the insurance medical evaluation doctor opined that Messing could work as a trial lawyer and that his depression was in remission. As a result, his benefits were terminated and Messing ultimately filed a lawsuit. But here's the problem. The IME won the day. When Messing submitted a rebuttal report to counter the IME, the report was long on conclusions, but short on a factual or medical basis. The rebuttal opinion that he obtained just didn't explain the factual basis for why he couldn't work as a trial attorney. Didn't talk about the problems that he had with depression or anxiety, the frequency of his depression or anxiety, how he would have panic attacks, how he would have difficulty interacting with others in his own family, how he isolated himself, how he would deal with stressful situations. None of those factual bits of information were ever developed. And, worse yet, there was no medical explanation as to why he couldn't work as a trial attorney. So there was no connection, or there was no development of the symptoms, and ultimately there was no connection between the symptoms and his inability to do his occupational duties as a trial lawyer. So you would have hoped that that rebuttal letter would have gone through the material and substantial duties of his occupation as a trial lawyer and explained why isolating oneself or not really caring about what happened in a case, or the fact that he would have panic attacks a couple times a day that lasted 20 to 30 minutes might actually interfere with his ability to be a trial lawyer. So as a result, the judge had no choice but to accept the liar for hire, not so independent medical evaluation. That isn't to say that Messing shouldn't have submitted a rebuttal report, but the quality of the report and the lack of support just doomed this claim. So what are the practical lessons that you need to learn here? The first lesson is if your doctor no longer supports your claim or refuses to render an opinion, you got to find a new doctor immediately. Got it? Number two, if you're set up for a insurance medical evaluation, you darn well better get your own, and you darn well better have your own IME doctor review the testing, if any, that the carrier IME has you undergo. Next, you want to have your IME doctor write a strong, factually and medically supported rebuttal point by point. And hopefully, your new doctor will endorse the opinion of your IME doctor. And lastly, Don't leave any weasel room in that rebuttal. You've got the burden of proof. You've got the burden of proof, and meet the burden of proof to get your disability benefits. I hope you've enjoyed this week's episode of Winning Isn't Easy. If you've enjoyed this episode, consider liking our page, leaving a review, and sharing it with your friends or family. And I would love it if you would subscribe to this podcast. Now, I also, before I close, want to tell you that we have just launched our 2022 Cavey Law Scholarship. It's up and running. It is open until August, and I want you to go over to caveylaw.com/scholarships and enter your family or friends or kids that you know that are looking for a college scholarship. Obviously, they're going to be having to complete the application, but I would urge you to get involved in the scholarship opportunity. I hope you tune in next week for another insightful episode of Winning Isn't Easy, and I look forward to reading the essays of people that you suggest apply for our scholarship. Thanks.